I can just live to 65. I'll have Medicare. It's a great program. We ought to expand it. We ought to make it universal. Mr. Ellison, I don't know how much time you have.
We got about 30 minutes or so.
Well, there are things we could talk about.
Yeah, I do. You know, I'd actually like to take up what happened with Eric Holder today, if that's the subject you don't mind.
Let's talk about it.
Well, you know, I tell you, the Holder case, Eric Holder, when he came in office, this program, the Fast and Furious, was ongoing. It was a gun-walking program. The original theory was that you put some guns into the stream of commerce, and then you can find out who's buying them, who's selling them, and try to get to the bottom of some of these cartels that trade in illegal guns, straw purchasers, and so forth. Well, it was a poorly conceived plan, and tragedy occurred. A border enforcement officer, Officer Terry, was killed as a result of with one of these guns. And we all pause in his honor and offer our sincere condolences to his family. Well, when Attorney General Holder found out about this program, he shut the program down. But then, of course, as facts came to light, it is a legitimate source of investigation, and he submitted to nine hearings, 8,000 pages of documentation. But when it finally got down to it, when there was information that was a deliberative nature, not on the facts of what happened to Officer Terry, but just exchange of information and pending criminal information, which everyone in this room should know is not for public consumption. When that information was sought, the administration, the White House said, no, we're going to exercise executive privilege. Obviously, if the President exercises executive privilege, the Attorney General has to abide by that decision. And despite all those facts, today on the House floor, the Republican majority, instead of dealing with jobs, instead of dealing with health care, instead of dealing with renewing the student loan interest rates, which are about to double, instead of dealing with the transportation bill, which is about to expire, we go do a witch hunt on Eric Holder. It's really too bad. Any thoughts on this issue you care to share?
Well, I do, and like most of my Democratic colleagues, we just walked out of this chamber, said this is not worthy of the dignity of the House of Representatives, and we weren't going to honor this process with our presence. Let's go back here. The Fast and Furious programs actually began in the George W. Bush administration, I think around 2005, 2006.
That's right.
And there were two iterations of it, two different projects that were underway in out of the Phoenix office of the ATF. And they were trying to find out who the gun runners were. And we've all watched the Western movies and the gun runners. Well, there are American gun runners that were running guns to the narco folks in Mexico. And wanted to find out what's going on here, where are these guns coming from, and so they went through this. And that was, once again, during the George W. Bush administration, gone on for 2 and 3 years. The Obama administration comes in, Eric Holder is chosen as Attorney General, and the program continued. The tragedy occurred, an agent was killed, and from there the gun, the Fast and Furious, that is what we now call the walking of the guns, became known. Eric Holder shut it down. In that process, a letter was written to the Senate committee saying that it didn't exist. Clearly an error, I am told, but this House doesn't know today, never investigated by the committee, but I am told that there was information that the office in Phoenix, Arizona, misled the office in Washington, D.C., and a letter was sent forth that was incorrect. That's the subject of the that should be the subject of the investigation. What happened here? What actually went on in Arizona? not one witness from the actual operation was called to testify, not one. So this is really a very strange and botched investigation. If you want to get to the bottom of it, you've got to talk to the people that actually did it. Didn't happen. The Democrats on the committee demanded several times, bring forth the people who did the Fast and Furious operation, from the Bush administration into the Obama administration. Bring them forward, get their testimony, find out what happened, find out about the communications between the Phoenix office and the Washington, D.C. office. Didn't happen. So in terms of an investigation, you have a partial investigation focusing on the end of the story rather than on the full story. And today, first time ever in the history of this nation, first time ever in the history of this nation, this body voted to hold in contempt a cabinet official on a half-baked, insufficient investigation that purposefully ignored calling witnesses that were actually engaged in the Fast and Furious operation and who were responsible in the Phoenix office for that operation. It was a farce. It was a political event, and we walked out. Not a good day. And as you said a moment ago, there are things we must do. Men and women and families across this country are hurting. They're unemployed. They want jobs. They want to go to work. Transportation. Where's the transportation bill? We never did get one out of this House of any meaningful. We just passed a little thing so we can get to conference. Had nothing in it, but it allowed us to go to conference. Where's that bill? How about the student interest rates? Where's that bill? And what about the jobs program? What if the September 2011 proposal that President Obama put forward,
the American Jobs Act. Yeah.
The American Jobs Act, what if we had taken that up? 3 million, 4 million Americans would be working today. What if we had done that? But it didn't happen. Our colleagues on the Republican side refused to bring it up in this House and refused to allow it to be brought up in the Senate. That's sad. That is a very sad thing for America. It's one of the great we should have, but we were prevented from doing so.
Well, Congressman, I have some obligations that require me to curtail our hour a little early. You can carry on if you like, but... Well,
I too must go, and but I thank you very much for the opportunity to talk about three very, very important things.
Well,
I appreciate that, Mr. Ellison.
You're here all the time. You're famous for nailing the need for a greater investment in manufacturing and supporting American jobs, and I thank you for all the great work you're doing.
You must mean make it in America.
Make it.
Spend our tax money on American-made equipment and jobs. Thank you.
What an idea.
What an idea. Spend our tax money on American-made equipment and jobs, not on Chinese or Japanese or anybody else, but on American jobs. We can do that.
We can do it. So let me wrap up by saying that it's been a great evening, a great day of great victory for the American people. Affordable Care Act has been vindicated in the Supreme Court. Unfortunately, the day is somewhat marred by the unfortunate behavior of the majority in trying to go after Eric Holder. Nonetheless, it's another day in Washington. Progressive Caucus will be back next week. Thank you very much. We yield back.
Gentleman yields back. The Chair announces the Speaker's appointment pursuant to Section 1238B3 of Floyd D. Spence National Defense Authorization Act for fiscal year 2001, 22 U.S. Code 7002, as amended, and the order of the House of January 5, 2011, of the following member on the part of the House to the United States and China Economic and Security Review Commission for a term to expire December 31, 2014.
Springfield, Virginia.
Under the Speaker's announced policy of January 5, 2011, the gentleman from Georgia, Mr. Graves, is recognized for 60 minutes as the designee for the Majority Leader.
Well, thank you, Mr. Speaker. And I rise today with a group of colleagues of mine to really speak in contrast to what we just heard, and it's really shocking to me, not only the news of today and the continuation of overreach of the federal government, but to hear colleagues on the other side of the aisle who are advocating for the progressive caucus, the progressive movement in this nation, celebrating, truly celebrating the Supreme Court ruling of today, which allows the federal government to continue reaching into the homes of American families all across this country in a way that has never been done before, and granted so much more taxing power that has never been granted before, and yet they celebrate. And they used a lot of different terms like charting the new course. That was a phrase that was used by the Progressive Caucus here just a moment ago. Charting the new course. And, you know, one has to wonder, what is this new course? I mean, it's been a course that the progressive movement has been on now for nearly a century. And today, they are celebrating that course continuing to be charted. And that is a course of more government and less liberty. And that is what this decision was all about today. It was about empowering government and not empowering the American people. It was about creating more government and less liberty. That's what the decision reflected today. But I'm joined today with many good friends here in the House of Representatives who are on the side of liberty. They're on the side of the American taxpayers. They're on the side of the private sector. They believe in free markets. They believe in capitalism. They believe in profits. They believe in success, in dreaming. And they don't think the federal government has to get in the way of any of that. And so, Mr. Speaker, I would like to first yield to the gentleman from New Jersey, Mr. Garrett, to get his insights on today's decision.
And I thank Mr. Graves for leading the floor tonight on this very important matter. But he joins me, I'm sure, in saying that we are all extremely disappointed that we have to come to the floor tonight, and that the Supreme Court today ruled that the Commerce Clause does not support the individual mandate, but that it may be upheld anyway within Congress's power. How? Well, to lay and collect taxes. So what we have found out today is that Congress cannot use the Commerce Clause to compel you to do something, but instead Congress can tax you into submission instead. It should have been crystal clear that the Commerce Clause, which grants power to Congress to provide free trade pacts among the states, could not use that clause to regulate it. If Congress cannot force you to purchase a product, then there's nothing government cannot force you to do. This would have been a violation of your individual liberties as well as your constitutional doctrine of enumerated powers, in which Congress is not only given few but specific powers. As the Supreme Court syllabus in this case states, and I'm looking at it, the framers knew the difference between doing something and doing nothing. They gave Congress the power to regulate commerce, not to compel it. Ignoring this distinction would undermine the principles that the federal government is a government of limited and enumerated powers. But what? The Supreme Court instead told us that Congress has the power to tax and tax and tax and tax until you submit to it. Now, is this all consistent with the founding principles of this country? You know, did those brave patriots who fought in the Revolutionary War and faced estrangement from their families, who endured British cannon fire and musket fire, who weathered freezing winters and blazing summers, march without shoes, sleep without blankets, and suffer with perpetual starvation, all so that Congress could now tax the people to conform to their own behavior that Congress wants? Did the founders who objected to the Stamp Act, the Sugar Act, and the Declaratory Act, which led our great nation to a revolt, risk the charge of treason and put their lives, fortunes, and sacred honor at risk, also that they could replace one king who demanded more from taxation and now replace it with a president who demands more from taxation? No. We are American citizens of a constitutional republic where individual is our birthright, won by our founding generation's sacrifices. We are not and shall never be mere subjects to a government that can tax its way to tyranny. And disturbing as it is, there are many problems with this majority court's rationale. You see, the Obama administration has been confused as to whether or not the monetary penalty for failure to pay is in fact a tax or not. But even if we accept the penalty as a tax, as this court has rewritten the law to be, such a tax is still unconstitutional for many reasons. First, the Constitution lays out three types of permissible taxes. A tax that is not assessed on income so it is unconstitutional in that regard. This tax is not assessed uniformly and is triggered by economic inactivity, so it's unconstitutional in that regard. And the tax is not apportioned among the states by population, so it is unconstitutional from that regard. Even more important than that, the Constitution does not grant Congress an independent power to tax for any purpose that it wants. Taxing to provide for the general welfare does not mean that there is limitless power of Congress to tax. Rather, it means that tax must be for a national purpose to achieve the ends that are outlined within the enumerated powers. Now, this is not my view only. This was the view of James Madison, who ought to know a little bit about the Constitution, since he is the man most responsible for it. There is nothing about the individual mandate defined as a tax that is sanctioned by the Constitution. But we have strayed far from the Constitution founders. No longer is the ability to tax constrained by the limits imposed by that great document. The growth and power of this government would render it not only unrecognizable, but also repulsive to the founders. Madison and his fellow revolutionaries worried about the growth of government and yielding to liberty. The writings they left for posterity are full of warnings about the fragility of limited government. Madison believed Republican governments would perpetually be on the defensive against the encroachment of aspiring tyrants. John Adams said, democracy never lasts long. And perhaps the most famous quote of all was Ben Franklin at the Constitutional Convention when he said, "We have produced a republic if you can keep it." And now, 225 years later, we have arrived at this moment. Perhaps we should strive then, not perhaps, but we should strive to restore the free society of our founding fathers that they fought for. If liberty then is our goal, the Supreme Court has failed the American people. And so although we come here tonight extremely disappointed that the Supreme Court did not rise to the defense of the Constitution, I can take solace with the knowledge that the people of this country will. See, the Americans of this country revere the Constitution, and they will not let it be trampled upon. They long cherish their liberties. They will not surrender them without a fight. Since the enactment of Obamacare, I have seen the tireless efforts of patriots, both in my district, in the state, across the country, trying to repeal Obamacare. And I am inspired by their passion, by their determination to defend the Constitution. This generation of Americans will not allow history to say that we presided over the demise of the American experiment in limited government. Now, it is true that the struggle against Obamacare has been long and difficult and sometimes met, as today, with disappointing results. But those of us who still believe in our founding principles, I offer some advice from Thomas Jefferson, who said, "The grounds of liberty is to be gained by inches." And so we stand here tonight all together, pledging to work alongside the people of this great nation, who will fight inch by inch in defense of the Constitution, and we will repeal Obamacare. Mr. Speaker, Obamacare must be repealed entirely, because if it is not, the constitutional republic and the safeguards of our natural rights through limited government will be lost. And with that, I yield back.
Well, thank you, gentlemen from New Jersey, for your remarks, inspirational remarks, reflecting back on the history of this country and the great leaders and the founders and the principles of which this nation was based upon. And while the erosion continues, and we've seen more of it even today with the ruling, the resolve is even stronger. So to those that may be listening or watching, you can know that there is a group of members in the House of Representatives that are not going to let up, that are going to be fully resolved to repealing Obamacare in its entirety, pulling it out, each and every root of this legislation, and empowering the people and not empowering government. Because, why? Because this is not a government of the court, by the court, or for the court. This is a government of the people, by the people, and for the people. And I am convinced that the people will have their voice heard in the next few months. So as we heard from the progressives earlier, and their continued march down this new charted course of more government and less liberty, we are thankfully joined tonight by a great friend of liberty and a great advocate of liberty, and that is Louis Gomer from Texas, and I'd like to yield to the gentleman from Texas.
And I sure do appreciate my friend from Georgia. Just an absolute patriot, standing for truth, justice, and what used to be the American way. It's according to the Supreme Court, not so much anymore. And I appreciate the gentleman from yielding. I've been going through this decision, and you know, having been an attorney, and I've been a prosecutor and a judge and a Chief Justice, and it's a small three-judge court, but you learn things. You go to judicial conferences about how to write opinions and things, never to the level of the United States Supreme Court, but as a certified member of the United States Supreme Court bar, you follow the holdings of the courts. And so it's been with great interest after got my wind back from having found that Chief Justice Roberts wrote the opinion for the 5-person majority. Okay, so I start going through the opinion. Let's see how in the world he came to this conclusion. Well, I'll be very brief in jumping through, even though it's a very long opinion, including the dissents. But the first thing that the court had to consider is the Anti-Injunction Act that was passed by Congress years ago that makes very clear the Supreme Court cannot take up any issue regarding a tax unless the tax has actually been levied and someone required to pay the tax, and then someone against whom the tax has been levied, required to pay that tax, files suit. That person then has standing. Well, under Obamacare, if the mandate is a tax, the penalty is a tax, then the Anti-Injunction Act would kick in, and no one would be allowed to have standing before the Federal District Court, Court of Appeals, and certainly not the U.S. Supreme Court. So the first thing, the Supreme Court had to get past the idea that the issue of, is this penalty a tax? Because if it's a tax, then the Supreme Court must throw this case out, announce that the plaintiffs in these cases have no standing and will not until around 2014, until such time as the tax is levied. So the court goes through, and if anybody prints out the decision, you can look at pages 11 through 15 specifically, where they discuss the Anti-Injunction Act. And they point out in essence what I've hopefully clarified. If it's a penalty, then the court can take it up. If the penalty that you must pay for not buying the insurance is a tax, then this case goes out, no Supreme Court decision for at least 2 to 4 years. So Chief Justice Roberts, brilliant man, there's no question, he's a very brilliant intellectual. He indicates this and says, Congress' decision to label this exaction a penalty rather than a tax is significant because the Affordable Care Act describes many other exactions it creates that are taxes. And he says this, he says, where Congress uses certain language in one part of a statute and different language in another, it is generally presumed that Congress acts intentionally. So he goes on and he says, the Anti-Injunction Act and the Affordable Care Act are creatures of Congress's own creation. How they relate to each other is up to Congress, and the best evidence, Supreme Court's words, Justice Roberts' words, the best evidence of Congress's intent is the statutory language, the statutory text. And so he goes on to conclude that since Congress says in Obamacare, the Affordable Care Act, boy is that a misnomer, Affordable Care Act, since Congress calls it a penalty, then Justice Roberts and the majority say it's not a tax. It is a penalty. So around page 15 or so, 15, 16, they come around and say, I guess 15, okay, Congress made clear that the penalty is what it is, not a tax. Therefore, the Anti-Injunction Act does not apply, so our court has jurisdiction And as he says, the Anti-Injunction Act therefore does not apply to this suit since it's a penalty and not a tax. And therefore, as he says, we may proceed to the merits. Okay, so it's clear it's a penalty, it's not a tax. Because if it's a tax, they can't do anything, they got to throw it out. Okay, it's a penalty, not a tax. So then he goes on after page 16, it goes on in the majority opinion to discuss this issue of whether or not it violates the Commerce Clause, this penalty. And he comes to the proper conclusion that if Congress can mandate a penalty for not buying a product, there's nothing to stop Congress from intruding in every area of individual Americans' lives. And that means, and it's mentioned in this opinion that the main purpose, one of the two main purposes, is to bring down the cost of health care. Supreme Court thinks that's a legitimate reason to pass an act, bring down the cost of health care. But Justice Roberts and the majority decide it would violate the Commerce Clause, because if you can force individual Americans to buy a particular product in order to bring down the cost of health care, you can order anything. You and I could be ordered to begin or to join a gym and to start exercising X number of hours a week. We're told that the federal government does not monitor debit card and credit card purchases, although supposedly it could. Well, if it has a duty to bring down health care costs, and it has the ability to watch your purchases, and under Obamacare, the federal government, through their relationship with General Electric, a sweetheart deal they did with GE, they're going to hold everybody's medical records. So if they're holding everybody's medical records, then I don't know why they wouldn't go ahead and monitor everybody's cholesterol rate, blood pressure, things like that. And so it could conceivably get to the point where, gee, you get a letter from the government that says, we noticed your cholesterol rate's up 250 or so, and we noticed you bought bacon this weekend. What were you thinking? You know, you got to take that back. You can't keep bacon. You can't. Anyway, there's no limit to what Congress can do to intrude in people's lives. And I'd point out to my friend from Georgia, you know, liberals are constantly on the protection of bedroom privacy rights. I really thought that once they fully examined the potential effect of Obamacare, they would be standing down here with you and me and my other friends here, Louisiana, Georgia. They'd be out here saying, wait a minute, if the government has the right to order us to do or not do acts or buy or not buy products for the sole purpose of bringing down the cost of health care, there are studies that say some certain relational activities create more risk for health care problems than others. So if this is true, the federal government would have the right not only to invade the kitchen and the bathroom, but head straight to the bedroom and dictate people's rights. I didn't want to go there, and I felt like once we found out that Chief Justice Roberts makes clear this is a penalty, not a tax. It violates the Commerce Clause to force people to buy a product like this. You would think that would be the end of it. But then Chief Justice Roberts goes on, and it doesn't make sense, because then he begins to say, well, it violates the Commerce Clause, but does it violate the Tax and Spend Clause? And then he goes through and makes a case for saying it's not a penalty, it's a tax. And he's already told us that the best way to tell what it is to look what Congress called it. And I think in this case, not only look what Congress called it, look at what the President called it. Just happened to have a partial excerpt, or an excerpt from the transcript of a show the President did with his friend George Stephanopoulos. And Stephanopoulos is asking him about it and said, you know, under this mandate, government's forcing people to spend money, fining you if you don't. How is that not a tax? Well, President Obama goes on and he lays out all this weak gibberish and eventually gets down. Stephanopoulos interrupts. He says, okay, but that may be, but it's still a tax increase. And the President says, that's not true, George. For us to say that you've got to take responsibility to get health insurance is absolutely not a tax increase. The President also says nobody considers that a tax increase. He's not done making clear the will of the Congress and of the President, who pushed this bill to make it his shining bill that he had passed through Congress. Stephanopoulos goes on and said, I want to check for myself, but your critics say it's a tax increase. President Obama says, my critics say everything is a tax increase. Stephanopoulos, but you reject that it's a tax increase? President Obama says, I absolutely reject that notion. Not a tax increase. So you would think that if Chief Justice Roberts and the majority, the other four, are going to uphold the President's prize bill, he might accept what the President said he's done in this bill. But oh no, after finding that it's not a tax, it's a penalty, then Chief Justice Roberts comes over to page 39 and he says the joint dissenters argue that we cannot uphold Section 5000A as a tax because Congress did not, quote, frame it, unquote, as such. And then he goes on and he says labels should not control here. What? He just said before Congress own expressed written intent and is the best evidence of what their intent is. And yet now he comes over here, page 39, and says, wait, we have to look at what the intent is, but labels should not control. So then he goes through and makes this ridiculous argument that it is a tax. And he says over here, page 44, the Affordable Care Act's requirement that certain individuals pay a financial penalty for not obtaining health insurance may reasonably be considered as a tax. Because the Constitution permits such tax, it's not our role to forbid it or to pass upon its wisdom or fairness. But then one of the big mysteries in this brilliant man's opinion for the majority uses the first person pronoun I. Now, you know, anybody that's been a judge, normally you go to judicial conferences, you have seminars, you have training as writing style. If it's an individual judge, sole court opinion, then you'll write it one way. If it's a multiple justice opinion, you write another way. You see first person pronoun I in dissents, even though it's really not the best grammar to use pronouns in dissents, but you don't see them in well-written majority opinions, and Chief Justice Roberts is one of the best linguists we've had on the court. And he takes Justice Ginsburg to task a few different places in the majority opinion, and yet she is one of his voting justices to support the majority. That doesn't make sense. You don't normally see one justice writing the majority opinion take off and criticize someone who's voting with him. That doesn't make sense. But here at page 44, he says, Justice Ginsburg questions the necessity of rejecting the government's commerce power argument given that Section 5000A can be upheld under the taxing power. He says, Chief Justice Roberts, majority opinion, but the statute reads more naturally as a command to buy insurance than as a tax. So now he's back to what he originally said before he says it is a tax. And he says this, and I, Chief Justice Roberts, would uphold it, talking basically a future perfect tense, I would uphold it as a command if the Constitution allowed it. I would uphold it. He's writing for the majority. There's no reason for him to have the first person pronoun I there. It doesn't make sense. I don't know. Maybe this part he was writing as a dissent and all of a sudden found himself in the majority, and amazingly nobody caught this problem of style in writing the opinion. It doesn't make sense that a man that smart would have a product this poor, using first person, criticizing another justice in the majority with him, and then saying what he would do. Well, he is doing. He's writing the majority opinion. He has no business saying that. And then he goes through and says the states also condemn Medicaid expansion exceeds constitutional authority under the spending clause. But basically he comes back and upholds it, then strikes down that you can't force the states to do these things. But remind my friends, the President says it's absolutely not a tax. The only way this bill gets upheld is if the Supreme Court finds it is a tax after they find jurisdiction by saying it's not a tax. But this is the same President said if you like your health insurance, you're going to keep it. He said if you like your doctor, you can keep your doctor. We found those were lies. He said it's going to bring down the cost of health care, and every indication we've seen, insurance has dramatically gone up. And I get tired of hearing people say, because their memories are poor in here across the aisle, well, look at the good things in here. 26-year-olds can be on their own parents' insurance. Gee, you can buy insurance across state lines because of us. We've taken care of the unfairness that some insurance use with pre-existing conditions as an exclusion. But I would encourage my friends, I know my colleagues here remember, back when they had the House, they had the Senate majority, they had the White House, Republicans, many of us begged them, let us do some bipartisan bills together. Because we can agree, it's not a problem. Let 26-year-olds stay on your parents' insurance. Heck, the insurance companies love that because they're usually healthier. It's not a big cost. So we were going to be able to agree on that. It was Republican. Heck, John Shattuck is the first one I ever heard saying you got to sell insurance across state lines. That was a Republican idea. So, of course, most of us supported that. And the pre-existing condition, most of us are aware of circumstances where insurance companies have been grossly unfair in using that exclusion, and we were prepared to reach some agreements and have bipartisan standalone bills. And I know my friend Dr. Price out here, he has some concern about health care, having devoted his life to it before government, trying to fix what government had done to health care. And people have been concerned about it. We were willing to agree on these things, but they would not have it. So to say without Obamacare we don't have these other things is simply not true, and it forgets current history. We were ready to agree on standalone bills. They didn't want a bipartisan agreement. They wanted the whole brass ring and to shove it around our heads, around our necks, and eventually down our throats, and that is what has happened. So I would encourage people. I've been amazed how many people have picked up laws and started reading them, and I would encourage them to read this bill. It's a strange, I mean, not the bill, but the opinion. It's a very, very strange opinion. It contradicts itself on so many levels. It takes the Obamacare takes away religious freedom. I'm Baptist. I see what they're doing to the Catholics, and I don't want to someday say I saw what they did to the Catholics and I remained silent, and then eventually there was nobody to object when they did it to me. We all have to stand together, and I'm grateful to stand with my friends. One other comment, I heard my Democratic friends before we spoke say, without this Obamacare bill, these clinics will die. There have been clinics before the Obamacare bill that helped. We have some in my district. They're doing wonderful work. They need more help. The best are really charitable institutions. The clinics are not going to die, but what I would suggest came from the President's mouth also was in his town hall when a woman in the White House, part of the town hall, said, Mr. President, my mother got a pacemaker, an advanced aged, and if the doctor had not met her, the cardiologist was not going to let her have a pacemaker. And so, and now after he met her, he said absolutely, and she's lived years beyond that since she's had a pacemaker. So would you consider someone's quality of life under your panels? We know they don't want to call them death panels, but whatever you want to call them, will they be able to consider the quality of life that people have before they agree or disagree to let them have a procedure? And the President beat around the bush, as he did with Stephanopoulos, but he ultimately said, you find the transcript, it's available on the net, he said, you know, maybe we're just better off telling your mother, take a pain pill. You don't get a pacemaker. You don't get these additional years of life. You get a pain pill. So when our friends across the aisle tonight say the clinics will die, I would humbly submit that based on the President's own words, it's not the clinics that will die under this bill. And I thank you so much for your generous yielding of so much time.
Absolutely.
It's a bad opinion, and I appreciate having the time to walk through some of it.
I thank the gentleman from Texas for walking us through the opinion, and I hope all those that were viewing this understand that this is about a tax now. This is a new taxing authority, in essence, a broadening of the taxing authority. And as Mr. Gomer brought up, this is unheard of. We will now have a federal government that can do whatever it wants to do through taxation. And you know, just thinking about the difference between tax and penalty, I guess one way to find out is, who do you send the check to, right? I mean, where's the bill coming from? I imagine it's going to be the Internal Revenue Services. I remember being in the Appropriations Committee, and the IRS before us, you know, they're wanting hundreds of millions of more dollars to hire more people for the implementation of Obamacare, and now we all know why, and we know what that agency or that department collects. So here's the crux of the decision today. While the court might have said, well, the federal government can't tell you what to do, they can sure as heck punish you through taxes if you don't do what they want you to do. And that is to be followed up here by my friend from Kansas, Mr. Hulskamp, who has got some great insight. Thank you for joining us.
Thank you, Congressman Graves. I appreciate your leadership. Sometimes we wish there had been someone like you on the court today. And actually, before we forget, one of the 5 votes that upheld Obamacare, one of those 5 votes in any other court of law, that justice would have recused herself. The decision could have only been 4-4. Justice Kagan should not have been in on this decision. In any other court, they would have been recused, and if the lawyer refused to recuse himself as their judge, they would have been violating ethical rules. Every attorney in this country knows that, including the Chief Justice, and they said nothing. But you know what? I'm not here to talk specifically about that. You talked about taxes. Other congressman friend did as well. In this bill, there are 21 tax increases by the definition of the court. But I want to talk about 2 in particular, because I believe when we look back on the American system of once limited government, this day, June 28, 2012, will stand as the definitive date in the advance of government tyranny. In today's ruling, a slim majority of the court has turned the Constitution on its head and ruled that the federal government, in effect, can force upon the American people anything it darn well pleases, so long as it's called a tax. Let's not forget, when our founding fathers put everything on the line, risking life, limb, and property to make us an independent nation, they did so in order to ensure that no man was taxed without representation. They also asserted that every man and woman has inalienable rights that are not to be violated by their government. They enshrined these concepts in the Declaration of Independence and ultimately our Constitution. But today, in my opinion, the Supreme Court offered a perverse interpretation of the Bill of Rights. They said, just across the street from here, said that even though you have a right to do something, the decision to exercise that right will incur a tax. The decision to exercise that right, said the Chief Justice of the U.S. Supreme Court, the right will incur a tax. Can you imagine the limitless possibilities for Washington? Why not extend this interpretation to other parts of the Constitution? For example, why not tax the exercise of your First Amendment rights? Sure, you've got the First Amendment rights, send your member of Congress a letter, but pay a fine to the government. That makes sense under this ruling. Sell a newspaper or publish a blog. Don't forget to tell the IRS and the new 16,500 agents they want to hire to enforce. What about a right to a fair and speedy trial? That's guaranteed, but, you know, that's yours to have, but for a fee. That's the lack of logic. Average Americans who love their Constitution, these are guaranteed. They're not allowed to be imposed if you pay the fine and the fee. But one thing in particular I want to talk about, Congressman Graves, that in addition to this health insurance mandate tax, the President's health care law creates what is clearly a religion tax. A religion tax? Yes, you heard me right. Even if you morally or ethically disagree with something being promoted, for right now, HHS Secretary Kathleen Sebelius, former governor of Kansas, look at her record. Most Americans would completely disagree with her moral views. But if you disagree with her mandates under the President's health care plan, it doesn't matter. You will still have to pay for it. If you dare to follow your conscience, maybe actually practice your faith, or no faith whatsoever, and refuse to participate, you will be fined. Why? You will be taxed because of what you believe and your desire to live it out. You will be forced to give your hard-earned money to the IRS in Washington, D.C. because of what you believe. That, my friends, is a religion tax. It's a faith tax. It's a direct attack on our freedom of religion. Now, the court today didn't rule on that. There are dozens and dozens and dozens of lawsuits coming on about the HHS mandate coming out of Obamacare. But this is the start. But a tax on religion. Do you realize if you refuse to participate in the system? I had an employer sent me an email, said, well, Tim, everybody's talking about the individual mandate. What about the employer mandate? I want to cover abortions for my employees. I refuse to participate. He will be fined $3,000 at a minimum for every single employer. Why? Because of what he believes. That's why we started this country, for freedom to believe as we ought, not as the government or as the king or as the Chief Justice would have us believe. But they didn't address this directly in this decision. They'll be coming. This is a shocking attack, I believe, on the first supreme right in the First Amendment to write, to believe in, and follow the God we choose. The Supreme Court may not have dealt Obamacare the death it deserved, but it's incumbent upon each and every one of us here in Congress and each and every American. I would have loved to witness a home run, knock it out of the park, and say it's clearly unconstitutional. And again, if Justice Kagan had been ethical, it had been a 4-4 decision. But they didn't worry about that. Ethics doesn't matter, it's just the end. That's kind of the progressive caucus approach. The end justifies the means, but not in America. Not in America. I ask all Americans to realize this decision is not about health care. It's not about health care. It's about liberty. And when we have created and designed a method by which future Congresses, future presidents can get around any limit in the Constitution, and the Constitution is a limit on my power, on every power of every member in this chamber, and every member across the way, and every president of the United States. That's what the Constitution does. It doesn't empower us. It takes away our power. And this court today, it says, if you call it a tax, if you use those 3 words, even though the Chief Justice says labels don't matter. He said labels don't matter. Then he turns around and says the word tax does matter. If you do that, it makes it suddenly constitutional. Anything you do, including attacking the very faith that is held by the Chief Justice himself, says you cannot hold that faith, Mr. Chief Justice, unless you are willing to be fined by your own government. That is a travesty of justice in this country. And what this means is we cannot overturn this with this president in the White House. This has taken an issue, and people are ready to work on it and says, you know what? This is going to be the issue for November 6th. This is the choice. Do you want the government to mandate and control everything in your lives as long as they use that magic word? They love to use the tax word. If you allow them to do that, you will allow them to be in every part of your life with this, which is an absolute contradiction to what this country is founded upon. I appreciate the leadership of many in this room. I am just a freshman. I was not here when this debate started last time. There's some of these colleagues that have been here fighting all along. But I tell you, if the folks in the 1st District of Kansas are any indication of what Americans are saying all over, this is the time they're going to dust off that Constitution. They're going to read it and say, my goodness, I don't want to lose this. It's too precious. We're leading the world, and now is the time to take back our government, take back our Constitution, and take back power out of Washington, D.C. So I yield back my time, and I appreciate the leadership of the gentleman from Georgia.
Well, thank the gentleman from Kansas and Mr. Hulskamp for your words, the unintended consequences. And I can tell you there are going to be an amazing amount of unintended consequences with the Affordable Care Act, which I'm not sure we can call it that anymore. I think it's more like the Limited Care Act. It's the very expensive Care Act. And for the progressives that were here earlier, and I know many folks listened to them, they were celebrating. They were excited. They were happy, gleeful, whereas we're lamenting but resolved to do away with this once and for all. So why would they be gleeful? Because it's their movement. That's what they've been trying to do now for almost 100 years, and that is increase the size of government, get it into the lives of the American people, dictate the behavior, and limit freedom. And I read recently that part of their agenda is to divorce the Declaration of Independence and the Constitution, but to use one and to prop up on that one so that they can almost sort of claim that they are for the founding of this nation. And we heard earlier it was the Declaration of Independence that was used, life, liberty, and the pursuit of happiness, and why they were celebrating that this was the right bill to be in law because of life, liberty, and the pursuit of happiness. If you can claim that with this legislation, there are no bounds in which you can go with this federal government. There are no limits. And as the gentleman from Kansas just raised, this is clearly not about health care. This is about freedom, and this is about liberty and preserving it for future generations. I'd like to yield to the gentleman from Louisiana, Mr. Landry.
Thank you, Mr. Graves. And Mr. Hulskamp was just on the mark. And I will venture to say that today's ruling actually extinguishes the fire of life, liberty, and the pursuit of happiness. It destroys life and liberty and that pursuit. The question today for this country can best be summed up by President Ronald Reagan when he said back in the 1960s in a speech, "Will history write that those who had the most to lose did the least to prevent it from happening?" This is a sad and tragic day for the Constitution. Where is the limits of our government? While the court has answered that the Commerce Clause does have its limits and gives us that ruling, it takes away by saying that Congress has unlimited taxing power. So its limits are unlimited. I guess that Congress now, when it sees fit to regulate an issue, an industry, need only now to turn to its taxing power, as Mr. Hulskamp said. This law was sold to us as a mandate and not a tax. And it was reaffirmed by the President that this is not a tax. But yet when the arguments were made to its constitutionality, this administration took the position that it was a tax, and the court agreed. So let's see the taxes. In 2010, an excise tax on charitable hospitals was enacted. The codification of the economic substance doctrine, a tax hike of $4.5 billion, was implemented. A black liquor tax hike, a tax that increases on the type of biofuels, was added. A tax on innovators of drug companies was enacted. A Blue Cross Blue Shield tax hike was enacted. A tax on indoor tanning services was enacted. A medicine cabinet tax so that Americans are no longer able to use their HSAs, their FSAs, flexible spending accounts, or HRAs, their health reimbursement pre-tax dollars, to purchase non-prescription over-the-counter medicine was implemented. The HSA withdrawal tax hike was implemented. A tax that will take effect this year, the employer reporting of insurance on W-4. Where are they going with that, Mr. Graves? Where are they going with that? Remember, not long ago we had a big debate about that now we're going to report to the IRS the amount of your insurance policy that your employer gives you on your W-4 because they want to tax that as income. And then taxes that will take effect in 2013. A surtax on investment income, a hike in the medical payroll tax. Wait, the medical payroll tax. I thought we had a payroll tax holiday. Not in 2013. We're going to get an increase. A tax on medical device manufacturers. A flexible spending account cap that is going to affect those parents who have special needs kids. So those parents who have special needs kids that the other side of this aisle claims to always want to represent, this health care law is now going to tax. An elimination of the tax deduction for employers that cover prescription drugs. A $500,000 annual executive compensation limit. An individual mandate excise tax. An employer mandate excise tax. A tax on health insurers. And the last but not least, in 2018, an excise tax on comprehensive health insurance plans, which will affect union employees. And so this ladder of success that we had in this country has now had 3 rings of it removed. Because now the government tells the individual, if you live below a certain poverty line, you'll be given food, shelter, and now health care, tax-free. And no requirement by you, who is receiving these, to pay anything back to the government. 0. So what is the incentive to climb? Because the moment you start to climb, you lose these amenities, and the government starts to take from you. So the decision becomes, can I jump high enough to grab a rung so that I can then start paying back and get more of the amenities that the government was giving us and I was provided. So let me conclude, as I began, by asking, will those who have the most to lose do the least to prevent it from happening? And as I spend time in this city, I have come to realize that the giants of America who have been memorialized for their great contributions to our society did not contribute with the goal of being memorialized, but did what was right and just in the eyes of the Lord with no ego and no agenda other than for the greater good. And that is what this country so desperately needs. We need those giants. Thank you, Mr. Gray, for your time, and I yield back.
Thank you, gentleman from Louisiana. Mr. Landry, and you brought up one major component of all this legislation. I remember the president in one of the State of the Unions, he said, we need tax reform. Tax reform. I think you got tax reform in this law. What did you say? 21 new taxes that are being implemented because of Obamacare. 21 new taxes, and yet the progressives earlier said, no, this is great for America. Free health care, affordable health care. No one has to pay. They'll actually get credits back. Somebody's got to pay. That's the way this place works. Whenever they're promising you something, they're taken from someone else, and you just laid out 21 different areas that impacts every American that the president promised he wouldn't raise taxes on. So I appreciate you doing that. And next, the other component of it is what's left. What really was in this health care law, this big government expansion, this overreach into the homes of American families, a tremendous amount is left. And I know Dr. Price from Georgia has been leading the fight not only against this measure, but for positive patient-centered, patient-driven measures as well. I want to thank you for joining us and sharing with us.
Thank you, Mr. Graves, so very much. I want to commend you for your work on this issue and your leadership for principled solutions in the area of health care and everywhere else. You've heard, I know, that Republicans think every day is the 4th of July, and Democrats think every day is April 15th. Why would I say that today? Well, we've been highlighting it in this conversation we're having here because our friends on the other side of the aisle believe that every day is another day to raise taxes. And today the Supreme Court of the United States said, you want to raise taxes? Have at it. Raise them as high as you want. In fact, the Democrats are so incredibly happy this day because it's not just that they can now raise taxes or fight to raise taxes on what we do. Goodness gracious, they can fight to raise taxes on what we don't do. In fact, if you don't do something, then the federal government can say, oh, you better do that or we're going to raise your taxes. And that's exactly what the court said today, which confounds and astounds everybody. I was privileged to sit in the court today, though, and hear the reading of the ruling, and Chief Justice Roberts said one thing I found very, very interesting. He said, quote, it's not our job to protect citizens from their political decisions. It's not our job to protect citizens from their political decisions. And that's exactly what this was. This decision was fixed on Election Day in 2008. This decision came down on Election Day 2008. And as a physician, I want to talk for a very brief moment here about the incredible importance of Election Day 2012. Because as you said, Mr. Graves, there are a lot of things in this bill that we're not just talking about money. As a physician, I know what we're talking about is people's lives, the health care of the American people. And nothing could be so important. Nothing could be so personal. And what the court said today is, let the things in there stand. The $500 billion reduction, $500 billion in decrease from the Medicare program. Taking the Medicare program and saying, you don't need that money, seniors of this country, you don't need that money. We're going to use it over here. What does that mean? What that means is that those seniors, your parents, your grandparents, the parents and grandparents of this great country, the people of the greatest generation cited by this country, are now going to have diminished health care. And how are they going to do it? They're not going to do it through the front door. They're not going to say, we're going to decrease this care for you transparently, openly. Oh, no. They're going to do it through the back door. Something called the Independent Payment Advisory Board that we've talked about before. 15-member bureaucratic panel. Non-elected individuals are going to have the power under this law to say, Dr. Smith, you can't do that for Mrs. Jones. If you do it, we're not going to pay you. That's the coercive power of this government. That's the coercive power that this court today said is okay. Well, Mr. Graves, you and I both know that's not okay for us and it's not okay for the American people. And that's why we stand here tonight and we say with every ounce of our being that the election that occurred in 2008 may have written this in stone, but there are some sandblasters out there. And what we're going to do between now and the first Tuesday in November is make certain that the American people understand and appreciate that there are folks in this town who are fighting as hard as we can to uphold the rule of law, to uphold the Constitution, and to adhere to those fundamental principles, especially in health care, the principles of affordability and accessibility and quality and choices for the American people. The bad news was written today. The good news is that you can solve all of these challenges in health care without putting the federal government in charge of a thing. We've got the solutions. We've talked about them before. We'll be going on the road now and talking about them from now until November because the American people want to know that there's somebody fighting for them in this town on their behalf, and we are. What we need from the American people is for them to stand up and say, no more. We will not tolerate a government that will reach into our lives and destroy quality health care in this country to the degree that the court said was okay today. I thank my friend for the wonderful work you're doing and for yielding me this time.
Well, I thank the gentleman from Georgia. Not only are you a physician, you're not here speaking on behalf of physicians, you're here speaking on behalf of patients all across this country and defending them, and I appreciate the great fight that you're putting on and the resolve that you have for each of us as you're leading us here as Republicans here in the House. So I thank the gentleman from